Hello viewers, today we will discuss the topic cyber law and components of cyber law. If you are in a school or in any educational institution, you are a student, you have to wear uniform and to follow the norms and ethics of that school or educational institution to create an order. Similarly, if you are in cyberspace, you are a netizen and you have to follow norms and ethics of cyberspace. In the knowledge society of 21st century, it is difficult to escape from being netizens. To match with the society, we must know the ethics, norms, rules and regulation of cyberspace. These norms, ethics, rules and regulations are called cyber law and is essential to create order in cyberspace. In today's society, computer, internet, information and communication technology or e-revolution has changed the lifestyle of the people. Today, paper-based communication has been substituted by the e-communication, paper-based commerce by e-commerce and paper-based governance by e-governance. Accordingly, we have new terminologies like cyber world, netizen e-transaction, e-banking, e-return and online contracts. Apart from the positive side of e-revolution, there is a seamy side also, and computer, internet and ICTs in the hands of criminal have become the weapon of offense. Accordingly, a new branch of jurisprudence emerged to tackle the problems of e-commerce and cyber crimes in cyberspace, commonly known as cyber law or cyberspace law or information technology law. Now, I would like to discuss briefly the components of the cyber law. It is difficult to answer this question that what are various components of cyber law because it's debatable concept. Many jurists believe that as cyber law is to create order in cyberspace, therefore every branch of law dealing with cyberspace would be covered under the components of cyber law. After the advent of information and communication technologies, we have various new concepts such as e-commerce, e-governance, e-contracts, e-transaction, cyber crimes, IPRs in digital medium and so on. Therefore, laws dealing with the computer, internet and with these various new concepts would be covered under the components of the cyber law. Further, telecommunication is very important aspect of information and communication technologies affecting cyberspace. Therefore, telecommunication regulation would also be covered under this net. Apart from this, cyberspace also has impact on various conventional areas of law such as criminal law, evidence law, business law, taxation law, banking law, financial law, consumer protection law, contract, tort, international and healthcare law, security law and so on. At international level, we have two main laws dealing with these new concepts. There is the Model Law on E-commerce 1996 and the Model Law on Electronic Signature 2001. Given the impact that cyberspace is having on law, will the idea of a separate legal field called cyber law endure? The answer to this query may depend on whether e-commerce and traditional commerce coverage and if so, how. Two methods of convergence seems possible. The first is incremental and evolutionary. Under this method, the details of cyber law will be slowly absorbed into the traditional fields of the law. Eventually, cyberspace aspects of IP, legal process, commercial transaction and other fields will become so commonplace that the study of the cyber law will disappear as a separate pursuit. Under this scenario, the cyber law serves only as a temporary signal that cyberspace is important. Its sole role is to prompt the traditional field of law to consider the unique aspects of cyberspace and to make the adjustment. However, experience of the countries that implemented such frameworks shows that such implementation has a tremendous positive effect on the development of international trade, the country competitiveness and its economy in general. Legal framework for the cyber law encompasses all legal aspects of interacting in cyber world. Often this relates to economic aspects of such interaction, since it is important to ensure that transactions that moved from real world into the cyber world are just as valid and that the rights of interacting parties are safeguarded. Accordingly, contractual aspects of cyber law seeks to establish the rules for the validity of contracts concluded by electronic means and procedures of enforcing such contracts or resolving disputes arising from such contracts. Another component of cyber law which was discussed was cyber jurisdiction, especially in e-contract. It was opined that in traditional commerce of physical world, the main principle on the basis of which the courts of the country have jurisdiction to resolve a dispute or intervene in the matter is that all material elements of the contract lie within the relevant country's territory. This is often not the case in e-contract, as cyberspace undermines the connection between transaction and physical location. Thus, jurisdictional aspect of cyber law lay down the basic principle that help establishing whether the courts of a particular country have the competence to decide the matter. Another important element of cyber law highlighted was law relating to privacy in cyberspace. Generally, contractual interaction in cyberspace are intentional on the part of both the parties. There can be many other situations where a person's personal data is collected by electronic means and subsequently used for a variety of purposes, be it a commercial or otherwise. In cyberspace, collection and use of personal data is made much easier and sometimes can be done without even the knowledge of person involved. This increases the risk of improper use of such data and may go against the individual's right to privacy. Thus, personal data protection is another important aspect of cyber law, which was discussed in the seminar together with the security aspects of cyber law designed to protect the individual's data. Another aspect of the cyber law that was examined was intellectual property in cyber world. The major traditional means of protecting intellectual property such like patents, trademarks and copyrights were explained and their relevance in cyber world was outlined. In particular, the system of domain names protection and trademark protection were compared and the application of the copyright to the computer programs was examined. Therefore, various issues discussed were the implementation of the public key infrastructure for secure transacting and identification. Then, issue of national security, vice versa human rights, in the particular the right to privacy. The third one is the issue of deciding which jurisdictions law apply and which countries' courts are competent in the case of contestation arising from electronically concluded agreements or electronically supplied services. The fourth one is the increased relevance of inter-country cooperation in journal and extradition arrangement, in particular in the context of increased trans-border infringement brought about through the information communication technologies. Then the fifth one is electronic evidence. The sixth one is issuing arising from the ICT's application to taxation, trademark, copyright and other digital rights. Now, I would clear you what is the Indian position relating to these concepts. India, most of the new concepts like e-commerce, e-governance, e-record, digital signature and electronic signatures are covered under the Information Technology Act 2000, which is in tune with the Model Law E-Commerce 1996. Further, it was amended by the Information Technology Amendment Act 2008 so as to make Indian law in tune with the Model Law on Electronic Signature 2001. However, for proper implementation of the Information Technology Act 2000, either certain amendments were made in some conventional laws such as Indian Penal Code 1860, Indian Evidence Act 1872, Reserve Bank of India 1934, the Bankers Book Evidence Act 1891, Negotiable Instrument Act 1881, or wider interpretation is given to others. Now, let us briefly analyze the need for the amendment of various conventional law or wider interpretation of others. Then I would like to discuss what are the amendments of some conventional laws. First, we would like to discuss amendment of the Indian Evidence Act 1872. Before amendment, there were only two evidence legally recognized under the Indian Evidence Act 1872. The one is oral evidence, another one is the documentary evidence. Electronic record was not legally recognized and was not accepted as evidence. Therefore, amendment was made in Indian Evidence Act 1872 to grant legal recognition to electronic record so that it can be accepted as a evidence. Now, I would like to clear you the amendment in the Indian Penal Code 1860. Under conventional law, offences could be committed against the documents. However, electronic record was not within the purview of the Indian Penal Code and hence no offence against the electronic record was recognized. However, after the amendment, when legal recognition was granted to electronic record, new offences against electronic records were also brought within the purview of Indian Penal Code. Then, the amendment of the Reserve Bank of India Act 1934. Before the amendment, electronic fund transfer between the financial institution was not legally recognized. Therefore, the Reserve Bank of India Act 1934 was amended so as to grant legal recognition and to facilitate electronic fund transfer between the financial institutions. Then, the certain amendment is done in the Bankers Book Evidence Act 1891. Under the conventional law, B books of accounts were not legally recognized. Therefore, the Bankers Books Evidence Act 1891 was amended so as to give legal sanctity for the books of accounts maintained in the electronic form by the banks, wider interpretation of other conventional law. So, apart from amending various conventional law, some statutes were given wider interpretation so as to properly implement the Information Technology Act 2000, like the Consumer Protection Act. A moot question here is whether a cyber consumer in a law is different from the ordinary consumer, or whether he is covered under the Consumer Protection Act 1986. A cyber consumer purchases goods or hires services using the internet, whereas ordinary computer uses traditional methods of going to the market physically, etc. Both are consumers under the Consumer Protection Act 1986. provided they fall within the ambit of the definition of consumer defined in section 2 subsection 1d of the Consumer Protection Act 1986. So in that sense, consumer means any person who buys any goods for a consideration which has been paid or promised or partly paid or partly promised or under any system of deferred payment, and includes any user of such goods other than the person who buys such good for consideration paid or promised or partly paid or partly promised under any system of deferred payment when such use is made with the approval of such person, but does not include a person who obtains such good for resale or for any commercial purposes, or hires, avail of any services for a consideration which has been paid or promised or partly paid and partly paid by promised or under any system of deferred payment, and includes any beneficiary of such services other than the person who hires or avail of the services for consideration paid or promised or partly paid or partly promised, or under any system of deferred payment when such services are availed with the approval of the first mentioned person. Further, for this purposes, commercial purpose does not include use by a consumer of goods bought and used by him exclusively for the purpose of earning his livelihood by means of self-employment. Here, consideration means something having monetary value in transaction of sales and purchase of goods by the multitude of the consumer consideration is in monetary terms. It means who obtains goods or avails services without consideration is not a consumer. As mode of acquiring goods and availing services is not important for a person to be consumer under this act, therefore, whether he is purchasing goods or availing services through internet or physically going to the market, he is a consumer, and Consumer Protection Act 1986 would be applicable to such consumer. Then we will discuss the complainant. Section 2 subsection 1b of the Consumer Protection Act 1986 define complainant means consumer, any voluntary consumer association registered under the Companies Act 1956 or under any other law for the time being in force, the central government or any state government, one or more consumers where there are numerous consumers having the same interest. In the case of death of a consumer, his legal hire or representative who or which makes a complaint. Then I will clear you what does complaint means under Consumer Protection Act section 2(1)(c). The Consumer Protection Act 1986 defines it means any allegation in writing made by a complainant that an unfair trade practice or respective trade practice has been adopted by any trader or service provider. The goods bought by him or agreed to be bought by him suffer from one or more defects. The services hired or availed or agreed to be hired or availed of by him suffer from the deficiency in any respect. A trader or the service provider, as the case may be, has charged for the goods or for the services mentioned in the complaint a price in the excess of the price fixed by or under any law for the time being in force, displayed on the goods or any package containing such goods, displayed on the price list exhibited by or under any law for the time being in force, agreed between the parties. Goods which will be hazards to the life and safety when used are being offered for the sale to the public. In contravention of any standards relating to the safety of such goods as required to be complied with by or under any law for the time being in force, if the trader could have known the due diligence that goods so offered are unsafe to the public, then the services which are hazards or likely to be hazardous to the life and safety of the public when used are being offered by the service provider, which such person could have known with due diligence to be injurious to the life and safety with a view to obtaining any relief provided by or under this Act. Further, goods under section 2 subclause 1I of this Act means movable property of every kind other than actionable claims and money, and it includes stocks, shares, growing crop, grass and things attached to or forming part of the land which are agreed to be sweared before sale under the contract of the sale. Under section 2 subclause 1O of this Act, service means service of any description which is made available to the potential user and includes the provision of facilities in connection with banking, financing, insurance, transport, processing, supply of electrical or other energy, board or lodging or both, housing, construction, entertainment, amusement of purveying of news or other information, but does not include the rendering of any service free of charge or under a contract of personal services. Then I would clear you the Indian Contract Act provisions 1872. There are several kinds of legal problems or disputes in e-commerce, especially in B2C model covered under the law of contract, such as the very first one is the e-merchant deliver goods, but the customer does not admit that he or she ever received the goods. Then another one is the e-merchant deliver goods, but the customer refuses to pay as his minor kid ordered the product using a parent's Visa card without authorization. Then the customer pays for the goods and the e-merchant fails to deliver them. Another reason, the customer pays in full but receive either the wrong goods or a partial order. Then the customer does not like the goods, but the e-merchant has no procedure for accepting the returned goods. Then the customer does not like the goods, but the e-merchant refuses to accept returned goods or gives credit to settle the dispute. Then the customer receives the good, but it arrives damaged. The e-merchant claims it's the carrier's responsibility and the seller is located overseas. The customer receives the good, but it does not operate properly. The e-merchant asks the customer to ship the product to the manufacturer at the customer's expense. The manufacturer has no in-house service center. Therefore, an important question is whether the Indian Contract Act 1872 would be applicable to such problems. It is significant to mention here that as such no amendment has been made in the Indian Contract Act 1872, but recently the Information Technology Act 2000 has been amended by the Information Technology Amendment Act 2008, by which section 10A was introduced so as to confer the validity on e-contract, which reads as under. Validity of contracts formed through e-form section 10A of the IT Act, wherein a contract formation, the communication of proposal, the acceptance of proposal, the revocation of the proposal and acceptance as the case may be are expressed in the electronic form or by means of an electronic record, then such contract shall not be deemed to be unenforceable solely on the ground that such electronic form or means was used for that purpose. Therefore, section 10A confers validity on e-contract. Hence, where of the proposals, the acceptance of proposals and the revocation of the proposals or acceptances are made in e-form, then such contracts shall be valid under the Indian Contract Act 1872 and shall not be unenforceable solely on the ground that such electronic form or means was used for that purpose. Then I will clear you the position of law of torts. Basically, tort is a civil wrong which involves civil liability and civil action. Most of the cases relating to the fraud, negligence, misrepresentation, false advertisements and IPRs, infringements are covered under it. Then the very first major components of the law of tort is strict liability. A product that produces the wrong solution causing injury to the others fall under laws of strict liability or negligence. The basis of the liability involves product liability and is covered under tort law. The moot question is that if such product is purchased online causing injury to another person, whether rule of strict liability would be applicable. Fraud. If an e-merchant give false advertisement on the website or sell wrong products, or a customer gives an unauthorized credit card over the internet, whether he or she will be liable for the fraud. Suppose a product is bought online but consumer find it defective. Again, here question is of liability. Here, depending upon how liability is worded, liability is one of the manufacturer. Generally, in such situation, every person involved in transaction, manufacturer, e-merchant and seller would be liable under the rule of strict liability. As the Information Technology Act 2000 is silent about the liability under law of torts if arise in cyberspace, therefore wider interpretation should be given to the existing law of tort to answer such questions. Then I will clear you the e-commerce and taxation. Like other areas, there are various taxation difficulties in e-commerce which still remain unanswered. However, by giving wider interpretation to the existing taxation laws, and such problems could be solved. Then copyright and patent infringement. The copyright and patent violation that comes under the intellectual property law are also big issues, especially when infringement occurs in cyberspace. Copyright law gives the author of a tangible product the right to exclude from using the finished work. Similarly, patent law gives the inventor of a product or a process the right to exclude other from using such invention. A moot question is, if there is infringement of IPRs, copyright and patent online, whether it is covered under IPRs laws. However, under Indian law, proviso to section 81 was incorporated by the Information Technology Amendment Act 2008, which provides that nothing contained in the IT Act 2000 shall restrict any person from exercising any right conferred under the Copyright Act 1957 or the Patent Act 1970. This shows that where there is a violation of copyright or patent right in digital medium, then author or inventor shall all those rights which are conferred under these acts. Now, we will like to discuss trademarks and domain names. Trademark infringement in digital medium and domain name disputes are other area which need attention. As the Information Technology Act 2000 is again silent about the trademark infringement in digital medium and domain name disputes, therefore wider interpretation should be given to the Trademark Act 1999 to answer such question. Now, I will clear you what is the cyber jurisdiction. Cyber jurisdiction or jurisdiction in cyberspace refers to a real world's government's power and normally existing court's authority over the internet users and their activities in the cyber world. However, Information Technology Act does not cover the important issue of the jurisdiction, which is very important legal aspect in deciding the place of filing the case. Therefore, present law of the jurisdiction in physical world can be applied to the cyberspace to solve jurisdictional issues. Then we would like to discuss what is the privacy issue. Privacy issue in cyberspace is another area of concern. It is significant to mention here that regarding privacy issues under Indian law, section 72 was there under Information Technology Act 2000, which provided penalty for the breach and confidentiality and privacy and reads as follows. Any person who in pursuance of any of the powers conferred under this act, rules or regulation made thereunder has secured access to any electronic record, book, register, correspondence, information, document or other material without consent of the person concerned, disclose such electronic record, book, register, correspondence, information or document or other material to any other person shall be punished with imprisonment for a term which may extend to 2 years or with fine which may extend to 1 lakh rupees or with both. However, if anything is contrary to section 72 and which is provided in this act or any other law for the time being in force, then section 72 will not be applicable. Further, 2 more sections were incorporated by the Information Technology Amendment Act 2008. There is section 43A and section 72A. Section 43A provides compensation for the failure to protect sensitive personal data, where a body corporate possessing, dealing or handling any sensitive personal data or information in a computer resource which it owns, control, operates, is negligent in implementing and maintaining reasonable security practices and procedures and thereby causes wrongful loss or wrongful gain to any person, then such body corporate shall be liable to pay damages by way of compensation to the person so affected. Section 72A provides penalty for disclosure of information in breach of law of contract. There is any person, including any intermediary, who while providing services under the terms of lawful contract has secured access to any material containing personal information about another person with intent to cause or knowing that he is likely to cause wrongful loss or wrongful gain, disclosed without the consent of the person concerned or in the breach of lawful contract, such material to any other person shall be punished with an imprisonment for a term which may extend to 3 years or with fine which may extend to 5 lakh rupees or with both. Therefore, we can say that basically there are 2 main components of cyber law. The one is modern, another one is the conventional. Modern component consists a new law dealing with the computer and internet and various new concepts such as e-commerce, e-governance, e-record, digital signature and electronic signature, etc. There is the Information Technology Act 2000 in India, enacted to create order in cyberspace. However, conventional component consists of various conventional laws amended or interpreted broadly for proper implementation of newly enacted law. There is the Indian Penal Code 1860, Indian Evidence Act 1872, the Reserve Bank of India and the Telecommunication Regulation, Law of Torts, Law of Contract, Taxation Law, Cyber Jurisdiction, IPRs and in digital medium, etc. Thank you viewers for watching this program.